Another thing that I became aware of when I became dean, and not only became the head of the faculty and the appointee of the administration, but someone responsible for the welfare of about 600 young people, is that law students are under a great deal of stress. Now, there have been studies that have been done that indicate that legal practitioners are under more stress than professionals in equivalently sophisticated fields. So they're under more stress than engineers, they're under more stress than doctors, they're under more stress than accountants. And those studies now have been repeated with law students, and the same finding appears, that they seem to be under more stress. So the question, of course, is why. I don't think law school is any harder than medical school, and we don't consciously engage in sleep deprivation, so why are our law students under stress? One thing I think that contributes to this is what you might call ethical stress. Law is an ethically ambiguous and complex field in the sense that, let's say, medicine or engineering is not. There are, of course, all sorts of ethical issues that cluster around the basic practice of medicine, but there is also an unambiguous core. Medicine is designed to heal the human body, and that's a goal that very few people in the society are going to question. And that serves as an ethical focus, an ethical foundation on which the student can rest. Also, medicine has a very clearly definable client. That client, or patient, is the human body. Everybody has one of them, and the goal of medicine is to produce health in the human body. And so, again, that becomes a very conceptually manageable way to conceive your task as a doctor. In law, we don't have any of that. It's not clear what is to the benefit of society with respect to law. Some people say we have too many lawyers. Other people say that the legal system is the glory of our civilization. And there are a number of positions in between those. Similarly, it's not clear who your client is or should be. It's not just that each human being is a client. Clients can also be abstract entities such as corporations. They can be ideas or causes. And law students come into law school and they find themselves trying to identify what their view of the law is, who they're serving, what's ethical, what's proper to do with law, and I think it's a source of stress for them. One thing that we've experimented with here is the idea that during their very first semester, law students should have one course, and it can be, we've experimented with 1 hour a week, where they have a chance to talk about their own experience, what they feel is happening to them, what their feelings are about the profession that they're entering, and interact with someone, and I think this is probably best done by practitioners, interact with someone who can guide them through and talk to them about what it is that they're experiencing. It isn't a matter of telling them what's right or wrong. It's a matter of giving them space to think about and interact with ethical ideas. And I think this would help in terms of reducing stress, and I think that's something that all law schools ought to look at, because some of the stress of competition, the stress of the fact that employers are looking for the students who do the best in each class, that is built into the legal system generally. It's too big and too general for law schools to combat. But we can certainly look at the sources of stress within our own institution and think of creative ways to respond to that. And what I've outlined is only one of them. There are a variety of others. I think law school has come a long way from the rigors of the Socratic method that I think was an unnecessary source of stress, but there's still a lot more to be done. Another reason to get away from the litigation model is, of course, the fact that courtroom litigation is now a rarity. It's the exception, not the rule. And this is true in both civil law and criminal law. In civil law, in, let's say, commercial litigation, there is an enormous incentive to settle the case. Trials are lengthy, they're expensive, and they're unnecessarily adversarial. Once you've gone through a trial, it's going to be hard to reestablish business relationships with your opponent, whereas in fact it may be essential from a business perspective to maintain those business relationships. Also, all judicial systems are very aware that they're overcrowded, and so another incentive to settle comes from the judges, who urge the parties to think through ways that they can resolve their dispute without going before the judge. And judges will very often take a very aggressive stance, particularly toward the party they think they have the weaker case, and tell that party, as long as you do that in the presence of both parties, it's fine, but tell that party, I am not impressed by your arguments, you are going to lose, and it's going to be a lot more expensive to you, you might want to think about settling now. And this is going on all the time throughout the United States. In criminal law, something between 95 and 99% of our cases are plea bargained, and only a tiny minority are going to trial. And so a litigation-oriented curriculum that looks at courtroom techniques in civil law, that looks at the elements of a crime that have to be proved in criminal law, is misrepresenting the realities of our legal system. And again, it's a matter of thinking about law in terms that are larger than mere doctrine. Thinking about law as a practice, using our social science acumen, using our knowledge about the learning process to think about ways that we can introduce students to the realities of modern law. A litigation course, for example, should not simply talk about courtroom techniques, but should also talk about all the fact-gathering techniques that in modern civil procedure that lead to that. It should focus on depositions, on interrogatories, on pretrial negotiations, because these are very often the things that constitute the bulk of a litigation practice. And very often litigators in contemporary society think of themselves as engaging in representation that position the client the best way the client can be to settle the case, since ultimately that's what's going to happen. And then, of course, the litigator has to craft the settlement. And at that point, the litigation merges with the transactional lawyer, because the settlement is not that different from a contract, or perhaps a contract novation. I've already talked about the importance of transactional law. In criminal law, we need to expose students to the entire range of the criminal justice system. We need to tell them not only about proving the elements of a crime in a courtroom, but also about policing, about prosecution, about punishment, about the plea bargaining process itself. And all these are crucial parts of a modern system that is no longer dominated by trials, but dominated by other ways of resolving cases or resolving disputes. In addition to plea bargaining, other changes in the criminal justice system have been moving toward different ways of resolving at least certain categories of criminal problems. And these, of course, are things like drug courts. There are things like restorative justices, where the victim and the criminal are put together in an effort to figure out some way of punishing the criminal that is satisfying to the victim and is rehabilitative for the criminal. We know that prison is very often a brutalizing experience, particularly for criminals who are not inveterate or career criminals. So the person, the drunk driver, the person who committed a liquor store robbery on a whim, or the person who is criminally negligent, is not necessarily a candidate for the same kind of punishment that the career criminal or the violent criminal or the super predator, to use a term that was popular in the 80s and 90s, should be subject to. And very often there are other ways of dealing with that criminal that are better for the victim, better for the criminal himself, and better for society. And this then, again, involves getting away from our focus on trial, our focus on the elements of a crime in criminal law, and thinking about all the other mechanisms that we might use to resolve a criminal case.